The Sidebar, Bracewell's podcast devoted to government enforcement investigations, corporate compliance, and white-collar criminal defense. I'm Matthew Nielsen.
And I'm Seth DuCharme.
And we are your host and both partners at Bracewell LLP, where we represent companies, boards of directors, and individuals in all manners of litigation, investigation, and enforcement actions.
Hi, everyone, and welcome to part 2 of our continuing podcast with Sid Kamaraju, a partner at Pryor Cashman and former national security prosecutor in the Southern District of New York, where we talk with Sid about the process by which classified information is handled in federal court and the balancing of equities and interests that allow proceedings to go forward while maintaining national security. Yeah, and just to get a little bit more granular, you know, with SEPA, to think about these steps, and you talked about SEPA is there to educate the litigants, to educate the court. I honestly forget what SEPA Section 1 was. Maybe it's a definition section or something, because in my mind, all these things began with a Section 2. So I'll have to go back and refresh myself as to what Section 1 is. But my recollection is that a Section 2 filing is essentially just an explanation of what SEPA is. It's an introduction, you know, to the court and to the parties, and essentially putting people on notice that this is going to be a little more complicated, you know, than the normal case. And my recollection is that in the SEPA 2 filing, it talks about all the other filings that will follow. Again, I'm going to have to look up 3 because I remember jumping from 2 to 4 in most cases. And then whether you get to 5 or 6 is kind of, you know, an open question. But 2 I recall as being noticed, 3 I can't remember, and 4 is kind of where the rubber meets the road on really, you know, digging in to what's going to happen there. So if you remember 3, and you know, God bless you, but could you talk a little bit about at least what goes into where I think, you know, the real sweat, blood, and tears flows, which is a SEPA Section 4 filing?
Well, hold on a second. I have the statute. We're just going to go ahead and read it for the listener.
Okay.
So
You know, I'm glad you brought up Section 2, because I think it informs everything that happens after it, right? Because what basically your Section 2 conference is as a government lawyer, and then more and more you see defense lawyers trying to participate in Section 2 conferences. But either way, it's where you alert the court to like what your classified information plan is, right? And so the government under SEPA has basically 2 options when it comes to classified information that's subject to the government's discovery obligations. Well, I guess 3, but 1 is almost never an option, which is get it declassified. Right. That's almost never going to happen. So if it's going to remain classified, then your 2 options are, and SEPA governs this. 1, you can produce the information in a classified form to the defendant. And then there's a process that follows from there that we'll talk about for how it's litigated as to its use in the courtroom.
And Sid, I just mentioned 3 is protective orders. So you already alluded to the fact that there will be a protective order. It was just killing me. I was like, how are we skipping a second? But 3 is protective orders. Sorry, I just had to clear that up. So please continue.
No problem. The other option the government has is if it's too sensitive to produce is what Seth was talking about, which is a Section 4 filing. And a Section 4 filing is a bear. Basically, what it is it is a motion to the court asking for permission to either withhold the classified information entirely, and we'll talk about the standard for that, or to produce it in classified discovery in some kind of summarized or substituted format that will protect the national security interests. And so the standard governing sort of a Section 4 filing is a little bit different in different circuits. And there's some specific requirements in the Second Circuit, for example, that don't apply in other circuits. But generally speaking, what the government's got to show is it's got to show that the information, while the information may be relevant to the case, it's not helpful to the defendant. And then there's kind of a third leg, which, you know, you really don't want to be on this if you don't have to, but it happens where, okay, it's relevant, it's helpful, but God, please don't make us turn it over because it'll really screw over national security, right? That's the Hail Mary pass in a lot of instances for prosecutors. But what you do is you make that filing. It's an ex parte filing to the court, which is a subject of some litigation, but courts have repeatedly upheld the government's authority to submit that filing ex parte to the court. It is often in like complicated cases followed by Section 4 conferences where you as a prosecutor and the judge will sit and discuss the information. Those also typically are ex parte, which is one of the reasons this statute is so frustrating to defense lawyers often. Because as Seth said, a lot of stuff is happening outside of the view of the defense.
It is the judge actually reviewing this information.
So he can. Typically, right. what you do in a SEPA filing is you describe it, and depending on where you are, what circuit you're in, you may submit supporting affidavits or documentation to show the national security harm. But judges certainly have the authority to request to view anything in particular. And I've had cases where judges have done that. Seth, I'm sure you have. It causes a lot of consternation for the owner of the classified information, but they're allowed to do it. And we talked earlier about security clearance holders. Judges, I think like the president, do not require security clearances. So they're allowed to see classified information in whatever form. So judges will often review it, if not prosecutors typically in a SEPA filing. And these are often, just so people have scale, these are often 100-page or more than 100-page motions that are being filed. So there's a pretty robust discussion of classified information in them usually. But judges will review them and they will make a decision as to whether the government's allowed to withhold it or whether the government has to produce it and in which form they have to do that.
Yeah. And the leverage there, Matthew, and I think this is important for people to appreciate. I think there's sometimes I know that there's been a fear around Article 3 prosecutions that there will be some kind of surprise, abrupt, sudden disclosure by a court of classified information. That's highly unlikely, I think once you see it from the other side, because, first of all, judges take their obligations very seriously. Second of all, they can't, even though they have the clearances and they have the authority from the bench, it's very difficult, if not impossible, for a federal judge to compel the component of a government agency to just show up and dump a bunch of files out on the table. What they can do is dismiss the case. And that's what puts the lawyers who are trying to litigate around these issues in a real pressure cooker, because, you've got to maintain credibility and respect and trust with the bench. You've got to litigate in good faith with your adversaries. You have obligations, that you take seriously to comply with discovery and to put that opposing party in an appropriate position to litigate the issues. But if you had, the nightmare scenario where the judge said, I want X government agency to come up here with a van full of documents and pour them out on, my desk because I want to be satisfied. And that government agency said, nobody told us this was going to happen. At the outset, this isn't what we signed on for. We're not doing it. Then the judge can say, fine, can't make you, but you don't have a case anymore because I'm not satisfied that you're doing this right. And I think, different judges have different levels of skepticism, perhaps. But I think early on in the process, if you have a good Section 2 conference, if you show the judge that you've thought through these things, if you've anticipated defenses and issues, if you really show you've done your homework, you're off to a good start with the judge. And that's the part, I think, Sid, that you alluded to, where defense attorneys, are really in a tight spot, because I think judges are sympathetic to the defense not having to front all their defense theories to the government, and they'll allow the defense attorneys to have these ex parte conferences. But you've got to be prepared to explain your defense theory, early on to somebody. And that's very different than just, getting up and throwing stones at the government's case at trial. And it's uncharted territory, I think. So let's say the judge reads the Section 4 and says, hey, I think you've got to tell these defense attorneys some stuff. They have a need to know if they're going to represent their client. You can give it to them in classified form so they can't tell anybody about it. And then let them make arguments to me as to whether or not they have to be able to tell a jury about it. So how does that play out? If you're a defense attorney now and you get this submission, are you going to run straight to the judge and say, it must make the government declassify it all? Or what do you do, once you get that submission?
If there is classified information that a defendant wants to use in furtherance of their defense, SEPA's got an answer. It's Section 5, since we're walking through the statute. What Section 5 is Section 5 requires the defendant to provide notice to the government and the court as to what classified information they intend to use at any hearing or at trial. And it's a particularly thorny thing for defendants for a couple of different reasons. One, it applies not only to documents, but also to testimony. Mm-hmm. So you have to think ahead, for example, to, am I going to be putting on a witness or am I going to be eliciting classified information from a witness? Which, anybody who has done a criminal trial on the defense side knows that some of your best stuff comes when you get the 3500 material, right, a few weeks or a few days even before trial. But two, once you identify the classified information that you intend to use, the government has an opportunity to say, no, they shouldn't be allowed to use it. And now you are litigating with the government as to the relevance and the admissibility of the classified information that you're using, which, to Seth's point from before, now you're not just talking about your defense theory with the judge at your own ex parte conference. Now you're fronting it. And this has been an issue that's been litigated over and over again. Defendants have regularly argued that SEPA is, in fact, unconstitutional in this way because it requires you to front your defense, and courts have rejected it. I'm not aware actually of any court that has adopted that position. And I know the Second Circuit has rejected it on a few occasions. Right. So the next step, right, is you identify with, in the language of the case law, specificity and particularity, what classified information you want to use. And courts have required defendants to get right down to like the lines on a document that they want to use. Right. Okay. Tell me, you gave me this page. What's the specific piece that you want to use? Right. That's very challenging to have to try to identify all of that for any lawyer, set aside somebody who's trying to defend a criminal defendant. And then once you've done that, the government then has a right under, just marching through, Section 6 of the statute, where Section 6 basically allows the government to say, no, they shouldn't be allowed to use that. It's irrelevant, or it doesn't satisfy the typical rules of evidence that govern every criminal trial. It's hearsay, for example. It's prejudicial. It's all of the things that you typically see in criminal prosecutions. If the judge agrees with the government, then that's the end of the story. And the defendant's not allowed to use the classified information. If the judge disagrees and says, no, government, I think it is relevant and I think it is admissible, the government gets one more bite at the apple, which is they can say, okay, fine, judge, it's relevant and it's admissible, but the only part of it that's relevant, or the only piece of information that's relevant, is this. So you should allow us to propose like a substitution or like a redacted version of the document. And so, I mentioned that trial I did of a CIA officer. In that case, we had hundreds, if not thousands, of emails that were all classified, that were, heavily redacted, that were litigated over for months as to what particular lines and words could be used and substituted in. And so the government, because sort of the intent of SEPA is to obviously protect national security consistently with the Constitution, the government gets a lot of opportunities and a lot of second bites at the apple, so to speak, to try to come up with a way that's palatable. And to Seth's point, if after all of that fails and the judge says, well, no, government, that's not going to work, then it's up to the prosecutor, because the prosecutor now is in a very uncomfortable position of either having to go back to the owner of the information and saying, we got to turn it over and this is going to come out in open court, or I got to dismiss the case, or I got to dismiss the counts in the indictment that rely on this. One final kind of like point on that is, at no point during this process can the court ever compel a U.S. government agency to declassify anything. That's beyond the power of an Article 3 judge. What the Article 3 judge can do is say, this is coming into evidence in court. And whether you like it or not, that's happening. And if you don't like it, then kiss your case goodbye. And so SEPA even provides for, and I've had occasion to use this, keeping evidence classified, but still admitting it into the trial record, which presents all kinds of logistical challenges. But at no point do you actually have to declassify anything.
Yeah, just on those logistical challenges, I remember, we're all accustomed to the court reporter sitting there typing away on the machine. And we had a court reporter in a conference for a classified session And at the end, the classified information security officers essentially said, okay, now we've got to keep your machine in a SCIF, which was problematic for the court that court reporter.
Didn't have a backup.
Yeah. Hey, so look, Sid and Matthew, I think it's an important point, to make. Look, Matthew, you've done a lot of export control work, international tech transfer type of work. Sid has alluded to, international terrorism and espionage involving the CIA. And I think most of our listeners would say, yeah, I can get why international terrorism case would involve classified information, right, or a CIA employee being prosecuted. That makes sense. But if we were to do a survey, Sid, or Matthew, and just look all around the country where a Section 2 notice has been filed, some public indication that there's classified information in the case, what categories of cases would we see? Are we only talking spies and terrorists here? Or does CIPA come up in other types of cases that might hit closer to home for some of our listeners?
I think it's tempting to think about classified information as being confined to kind of those spies and terrorist cases, but you see it in any number of cases that you wouldn't imagine. For example, I know there have been instances in which insider trading cases have had CIPA violations. We were talking a little bit before about how sanctions enforcement is a increasing sort of area of priority for the Department of Justice.
Yep.
And sanctions cases almost inevitably involve some form of classified information that you're going to have to deal with. Same with export control cases, all of those types of things. I think as you see more and more FCPA cases come in, I think you're going to, you find classified information issues there. So while I think there's probably a trend towards sort of the terrorism cases and those kinds of things in people's mind, I think anytime you have an international component to a case, there's a real chance that there's going to be classified information at issue. Right.
I mean, in so many of those cases, you're either, and I'm sure there's other situations that Sid or Seth you can think of, but it could be from a tip that the government received from an informant, right? Someone trying to, maybe even in another case, trying to save their skin and cooperate with the government. And I think a lot of people probably just know this, but classified information is not held just at government facilities, right? I mean, there are a lot of government contractors, especially in the defense industry, that the government relies on in designing, manufacturing, modifying very classified, sensitive weapons and systems. And how those companies handle that, is subject to a lot of issues, right? I mean, it can be anywhere from, again, the extreme cases, would be espionage, but it can be as little as, ensuring that you don't have a non-U.S. national from a sanctioned country having access to the server that information is sitting on. Because if you do, that by itself could have implications and violations of U.S. law. So no, I think that you're going to start, I think this is beyond just the bread and butter and the, great work that you guys did to protect the, country. It can come into a lot of different type of cases, and people do need to understand that these statutes and, the challenges. I mean, you start thinking about some of these challenges that you guys have talked about. And as a defense lawyer, trying to figure out, you're always trying to figure out, as far a Brady material is, did I get enough? And of course, even the best intentioned prosecutor, the defense lawyers often think I should be getting more, right? You haven't given me enough. And, I don't know what I don't know. And especially in this situation, how do I argue about what I don't know? Because this is happening somewhat in a, like I said, in an ex parte fashion where I don't get to have the benefit of seeing all of the information and what's being given to me and what's not being given to me.
Well, I was just going to say, and sometimes that's a great point, and it can get particularly challenging for defense lawyers in these cases because sometimes you're not allowed to discuss the material with your client. Right. There are instances in which, as a defense lawyer, you may be given access to the classified information, but you're not, just due to who the client is or the nature of the information. The court does not authorize you to share it with your client. And that can create not only sort of logistical or strategic problems, but also trust issues, obviously, right? In terms of dealing with somebody and representing somebody, but having to say to them, I can't tell you everything, presents a, that's a problem.
I've had it on the other side representing some government agents in some internal investigations. And it's like, I can't tell you, sorry. So the client can't tell me the information.
No, these are great points. And look, ultimately, it's always about, assisting a client by being able to tell them what the issues are going to be and what's going to happen next. And, there is a body of case law out there. You can read in Second Circuit. I think, the Aref decision is probably, still one of the most cited cases on what SEPA means. The SEPA statute is out there. There's at least a handful of unclassified SEPA opinions by judges in export cases. And more judges, I think, have made an effort to redact as little as possible to give greater transparency. But it's hard to get smart on this stuff fast in a reactive posture. So you've both done, I think, a great job of cataloging all the different types of scenarios in which, this could arise. I think for our listeners, if you're a client or a lawyer who lives in a world where anything can touch on one of these classified equities, it really pays to think about in advance, what would happen if there were an investigation or a government action. If you were trying to say help a client get delisted, right, with the sanctions. IEPA contemplates ex parte classified submissions, to a court. So expectation management with clients, I think that's our job, at the end of the day. You can tell a client, this is what I think is going to happen. And this world, it's a difficult one to do that. But if you overpromise and underdeliver, that's a problem. So I think this is one where you really have to be a little bit cautious, in telling a client exactly how this is going to play out. You can help them spot the issues. You can tell them what the process is. But these are tough cases. We're doing our best to demystify this. We also, of course, have to be respectful of these particular equities. So I'm sure we have a bunch of listeners saying, why don't these guys just, speak in plainer terms? Like, what are they talking about? And we can't. That's the point, right? It's all, say the least amount possible to satisfy, the interests of justice and comply with the Constitution. I will say, though, these summary substitutions, I think there's an expectation that they're always somehow favorable to the to the government. Oh, this is great. We can just, as the government, we don't have to give them all the underlying information. We can just give them a substitution. My experience is that those summary substitutions always actually tilted in the favor of the defense. They amounted essentially to stipulations of facts that were somehow helpful to the defense. And we stripped away sources and methods and techniques and things like that. But ultimately, you're just handing them on a platter the good facts and not contesting it. So it's not all bad for the defense if it's done artfully.
Yeah. And I think that's a great point. And I think that's another reason why it's helpful to have defense counsel who's experienced with these kinds of issues, because obviously the ideal scenario for you, if you're a defense lawyer, is to just get the juicy fact with no cross-examination possible and no rebuttal essentially from the government. Right. And if you know how to do it, you can cut to the chase, right? And judges, because they sort of recognize the disadvantage that defendants are put at, if you as a defense lawyer can propose a solution to a judge that doesn't make them or doesn't force them to confront the thorny classification issues, often the judge is going to say, government, why not? Why wouldn't we do that? Right. And, to Seth's point, you can end up with some great facts in that way, right? You can end up with things that you otherwise may have had a hard time litigating. Chain of custody, for example, and authentication is a really difficult thing for a defense lawyer at trial, right? Because often it's not your people who seized evidence. Right. But through the wonder of SEPA, you can get stipulations. You can force the government to admit things because and we were talking about gray mail earlier, not endorsing gray mail, but I am saying if you know what the pressure points are, you know the ways in which you can ask for these things. And so I think you're right. There is a way for a defense lawyer to kind of work SEPA to their advantage in those instances.
Yeah, and I think, in fairness, all litigation is one form of gray mail or another. Get right down to it. There's always some jockeying, going on there. So yeah, I think you're 100%, right, Sid. And And Matthew, I know you've touched on a number of the types of cases, and will continue to touch on cases where these things, may present as an issue. So just, getting it all front of brain for us now. And I think obviously as conversations are playing out, in a very public way right now, the more people can understand about the processes that are in place, the fact that there are processes, the fact that this isn't all new. Frankly, in the last 2 decades, I think courts have gotten much more accustomed. There are a number of judges, who are repeat players with SEPA filings. And so, they get it from the moment the Section 2 notice is filed. They say, oh, I know how this is going to work. So, the good news side of this is that it is navigable. It's hard, but it can be done well. I think federal judges are equipped to stay focused on the equities, that they protect, which are the constitutional principles, while still being respectful, of the national security. We've seen it play out a number of times. We haven't, broken the machine yet, Sid. And I know that was the fear going back probably, 10 or at least 10 years and probably 20. Our stuff was never meant for litigation. Don't break the machine. And I think we should draw some encouragement from the fact that defendants have been able to fairly litigate a lot of these issues. And we haven't yet broken the machine. So those are my sort of final thoughts on this. I don't know how optimistic that sounds, but I think it's hard, but it can be done well on both sides.
Yeah, I completely agree. I think it's always a process, and it's always a process that needs tweaking with every individual case, but there's a framework out there to be able to do it. And I think for a lot of people, as you mentioned, that was inconceivable, a decade or 2 decades ago. And so I think that's progress. And I think for anybody out there who is awash with information about what's happening and how that may play out into their life, there are people who can help you sort of work through this and figure it out and kind of walk you through how it happens. Yep. So,
and Sid, stating the obvious, Sid, you are one of those people, and collectively, we are all here to help. So, Matthew, I'll give you, final thoughts or questions if you have any.
This has been a great and interesting discussion. And Sid, we really appreciate you joining us and educating our listeners a little bit about this, kind of what we keep saying, timely topic without talking about the elephant in the room. But no, really, really interesting. And I think we'll see how this, probably plays out in the public in pretty interesting matter, but it's interesting to see how it plays out in the real world, getting your great experience. So
yeah, thank you so much, Sid. And I really will say I am delighted, to reconnect with you on this side when we used to run into each other, slump shouldered with red eyes, dragging around courier bags, dreading an upcoming SEPA 4 deadline. And we said, how are we ever going to translate this into private practice? It seems important right now, but I can't imagine anybody's ever going to be even slightly interested in this, once we're on the other side. So I'm delighted to reconnect with you and find some continuing relevance in the years that you dedicated to the service of the United States and the protection of the people, particularly of New York, but really all free people around the world. So thank you for that. You're really one of a handful of the best in the business. I know you're too humble to say it, but you know what you're talking about. So we really, really appreciate you coming on and joining our conversation.
Listen, guys, I appreciate it. This has been great. I really, I'm thankful for the opportunity to go down memory lane a little bit, and obviously to talk to an old friend, Seth, who likewise has been deep in this world and has prosecuted some of the biggest cases involving this information. And so if there's an expert out there, I'm lucky to be able to talk about it with. So this has been great, and thank you, guys.
Thanks for the kind words. We'll stay in touch. Take care, everyone.
Well, thank you for joining us for this episode of Sidebar. You can get this episode and others off of the Bracewell website and anywhere where you get your podcast.